Hello, everyone. Good afternoon. My name is Paul DeBlasi. I'm with the Pro Bono Center. I'm the managing attorney for housing in the Pro Bono Center, and I'm being joined by my colleague, Kate Room, and also Nadej is here. Thank you, Nadej, who helped organize all of this. Really appreciate it. Um, and we really appreciate you all joining us here for this training for the Landlord Tenant Resource Center, where we'll be both talking through the sort of the procedures, the operations of the resource center, as well as practice in landlord tenant to help you with providing legal information to tenants and landlords, and how to think about being client-centered in engaging with persons that are reaching out for assistance with their landlord tenant disputes, which is also like a really important part of thinking how to engage with people who call in a way that helps center their goals and addresses the fact that they're coming at a time where they're experiencing probably a lot of stress, and there might be a lot of different issues involved in trying to help them in the best way possible. So before we begin, Kate, do you want to greet everyone, and then we can begin with the presentations?
Yeah. Hi, everyone. My name is Kate Riom. Like Paul mentioned, I'm one of his colleagues. I am the pro bono support attorney for housing here. If you've been in LTRC before, you may have been with me. And if you've taken a case with us, I may have been your mentor.
Okay. Yeah, and again, we're very excited for you all to be here. We'd like to ask that just to preserve the bandwidth for the presentation, if everyone could keep their screens off while we give the presentation. If we also ask that if you have questions to put them into the chat, please. We'll be monitoring the chat. We may wait to answer some questions till the end to make sure that we get through the presentation. And again, this presentation is going to be recorded so that you'll be able to review this later on, and also share this presentation with your colleagues so that they can also view this presentation to refresh on what they need to know for the landlord tenant to participate in the Landlord Tenant Resource Center, and for those colleagues that are your colleagues that are beginning at the Resource Center, to help them get grounded before they first start volunteering. And so that being said, I think we could begin with the first part of presentation, Landlord Tenant Resource Center operations and training. If you want to begin, Kate.
Yeah, absolutely. So we'll be getting started here. This is our operations training for everything about volunteering with us and all of the logistics. Then afterwards, we'll get into more substantive areas of law. So we're going to get started with LTRC basics. And LTRC, by the way, is our abbreviation for Landlord Tenant Resource Center. So just know if you see that, that's what we're talking about. So what is the LTRC? It is a resource line that stems from the Landlord Tenant Legal Assistance Network. So we have two different resource lines for tenants in DC. With LTLAN, tenants are able to get legal advice, brief service, sometimes even connected for representation. We do reserve those services for those that are more in need. So there are some salary and income cutoffs for LTLAN, whereas almost everyone else who's a tenant in DC can come to us in LTRC. And because of that, in LTRC, we provide information only. So no advice, no brief service, and definitely no representation through LTRC. We have both the remote hotline, and we are back in person on Tuesdays for some limited, very, very limited brief services, which really doesn't encompass us representing. It's more of us helping people fill out forms that we can't really do over the phone. And we are staffed by, of course, some of our wonderful volunteers, some of you who have done it with us for a long time, and our Pro Bono Center staff. All right, so a little bit about who we see in LTRC. DC has over 700,000 residents at this point, and 16.6% of our community members live below the poverty line. And a lot of our LTRC callers are those who are living below the poverty line or who are experiencing poverty. Even if they're not below it, they're still experiencing it. A little bit about housing in DC right now. average rent for a 2-bed apartment is upwards of $3,000, whereas the average income for a family of 4 is about $140,000. So as you can see, those numbers don't always balance. Tenants are facing some increasing rent prices and some very difficult decisions with rent and housing conditions. As probably most of you know from living in DC, we have a very rare race demographic. We actually have nearly 50-50 with our Black residents and our white residents. And you can see that demographic right there. And in terms of age, we have a pretty good spread, but we are also kind of a young city. We have a lot of people who are in like the younger age. So that's who's coming in to see us. And in terms of what types of cases we're able to hear in LTRC, for landlords, it is extremely limited. We're only able to talk to landlords who have under 4 units and do not use a property management company. On top of that, they either have to have an active eviction case or a case that was closed within the past year. So that's the very limited side for landlords. Tenants, we're able to help tenants of any income level with this whole wheel of areas. So the ones that we see most frequently are definitely housing conditions, active evictions, and illegal lockouts. But we also do get a few for self-help evictions, voucher terminations, utility shutoffs, record sealing, etc.
Thank you, Kate. So now I'll talk a little bit about volunteering in the LTRC. The eligibility to participate in the LTRC are for attorneys who are members of the DC bar, members of another US bar, so that's like of another state or jurisdiction in the United States, or attorneys that have taken a bar and are waiting bar results. And then for that, they also need to have a dean certification from their law school. And that's the criteria for someone to be able to participate as a volunteer attorney with a LTRC. Currently, as many of you are already doing now, we have remote volunteering, and that connects to that hotline that Kate was talking about earlier. To do that, you'll need a Litify account, and you will receive an email from the LTRC supervisor on the day of your shift, typically around 9 a.m. with instructions on setting up a Litify account if you don't have one from a prior shift. So many of you that have already volunteered will already have that account set up, but if not, then it could all be handled the day of your shift. And Litify, it is a website where it's like a web-based app that you can go and access. You basically get a link to then access that website. And then once you're set up, you'll be on the phone. You'll need a phone to participate as well. You can use your own phone, you can use an office phone, or even an app like Google Voice. And then you'll be receiving, and you can communicate with the LTRC supervisor both. You can call them, you can communicate in the case management system, you can also email in response to that email that you get in the morning, whatever works best for you and the pro bono center staff person that's supervising the LTRC that day. And shifts are from 9 a.m. to 2 p.m. And this is every weekday that the Landlord Tenant Assistance Network, Legal Assistance Network is open. And if you'll not be available during any portion of your shift, you could please let your firm know in advance. And also, it doesn't hurt to let the LTRC supervisor know in advance so that we can make allowances. Just to make sure to think about that in terms of the timing. And while it varies a great deal, I think from shift to shift, you could expect to potentially have 2 to 3 callers on a given shift at the Landlord Tenant Resource Center. Talk a little bit more about the process in Litify. All caller assignments will go through Litify. So you'll receive the caller's information, brief description of the reason for calling, and what legal information to provide from the LTRC supervisor. And this is a key point that although later on we're going to be talking about some of the fundamentals of landlord tenant practice, every time that you are working a shift at Landlord Tenant Resource Center, you'll be receiving guidance from the LTRC supervisor about what information to provide to the caller. And certainly you might have questions about that, or new issues might arise after you speak with the caller, but you'll be getting concrete guidance about what to communicate to them and what information may be helpful to them given the legal problems that they have presented, at least so far, as we understand them. If you have questions, let your caller know. You'll call them back. And then please check in with an LTRC supervisor. And as I said earlier, you can tag the supervisor in the chatter. That's a way that you can update in Litify. You can also send an email, give them a call, do all the above to make sure that you get in touch with the supervisor to help guide you through how to address whatever questions or issues have been raised in speaking with the caller. And remote volunteers, and this is something that Kate will talk about in a little more detail, can only provide legal information. We are not offering brief services, help filling out a motion, etc. for remote volunteering, and we're certainly not giving legal advice or other kinds of representation, although it's possible that if the person is seeking legal representation, we can assist with some referrals for that person. And then we're going to look, this is just a little bit of an example of what you'd be looking at. If you, when you get on to Litify, this is your home screen. You'll see that these are examples of what you'd see in terms of callers that have intakes that have been sent to you. You'll see the names of the caller as well as the intake number, and this also has statuses, which might be which would change throughout the course of the day as you affect those statuses. And then if you go on to the next page, you can see what this is what it looks like once you actually click on one of those callers and look at the information. So as you can see, here is information about their case number, which is something that the LTRC supervisor will already have looked at. There'll be the client's name, there'll be, and down below, you'll see the beginning, again, not all of it because it's quite extensive, but this is what I was talking about in receiving guidance from the LTRC supervisor. You can see the intake notes talking about the issue that they have and then going on to the kind of legal information to provide the caller to try to assist them. And over here, you can see how you can note whether contact was made or was not made with notes following that. Down below, you can't entirely see, but there's an option to send an email via Litify to the caller to kind of follow up with information or to share documents for them to fill out. And there's also a way to update and tag supervisors to ask them questions as well. And by tagging, I mean, you put an @ sign and then their name and it becomes active, and then that notifies the supervisor that they've been that there's a message for them to respond to. And just sort of some basic points we want to make in terms of what'll be useful in many of your instances when you're when you're helping callers at the resource center. And again, the supervisor will be there to help with all kinds of questions. But one is that if the caller is looking for representation, as we said before, the LTRC cannot provide representation. Occasionally, we can accept tenants who meet certain requirements for referrals to the Advocacy and Justice Clinic, which is another program at the Pro Bono Center. And the LTRC supervisor will be able to determine if a caller should be referred. Otherwise, we may have other referrals to assist the caller, which may include getting an attorney that they would have to pay some amount, even if it's a relatively low amount to represent them. If a caller doesn't speak English, we'll often have identified that before a case is assigned to you. We'll give you language line instructions, but if that emerges when you speak with the caller, then reach out to the supervisor and they can give you the instructions for language line, which is a service that we have that allows us to call people with an interpreter to be able to speak with them in whatever language they need to be spoken with to get the legal information they need. If caller needs more help than just a phone call, you can refer to the LTRC supervisor, who will assist the caller with reserving an in-person time slot or to help them with getting connected to in-person services or some other kind of referral. And so certainly that's, this is part of the ongoing conversation you'll have with the supervisor about how to help provide assistance to the caller on that day. And if caller needs a follow-up email, you can please send a draft email to the LTRC supervisor for approval before sending through Litify. So earlier we saw a little bit of a peek of that at the bottom of the screen of the field for that. So that's where you could send an email using Litify as opposed to your own work or personal email. And so you can also use that to send emails, and you can you can talk with the supervisor about what the content of that email should be. Now, in terms of volunteering in person, as Kate mentioned, we are excited about having returned to the courthouse on every Tuesday from 10 to 3 for in-person Landlord Tenant Resource Center. There we do, people walk in for legal information, and we provide legal information to tenants and landlords. We also refer cases for extended legal, for more legal services to other legal services providers at the courthouse, as well as some of our staff attorneys may actually provide representation to tenants. But certainly volunteering as a volunteer attorney at the in-person resource center, we'd be only providing legal information and other assistance like filling out forms. To do that, volunteering in person, you'll need a laptop to access Litify, a phone, and like remote LTRC, you'll have a script to read through when you first meet with the caller. And as many of you may know, I shared with the firms the information to show interest. I know actually, I think some people in this meeting have shown interest, which is great. We'll be following up soon. But if I'll be sharing that that form again to show interest and kind of dates that you might be available, Tuesdays in the coming months that you might be available, so that we can get you looped in to volunteering for in person. And there will, besides having the script, there also will be training that we'll be designing specific for that. And on the day of, there'll be a brief training before actually beginning to meet with tenants and landlords seeking assistance. But as described here, if you're volunteering at the in-person resource center, then you'll be checking at least twice, and perhaps many times, with the supervisor who will be there on site once before meeting with the caller or with the person seeking assistance, to kind of craft what kind of legal information you're going to provide and potentially what other forms to fill out. And then after the initial conversation, again, checking in with the supervisor to make sure that there isn't any additional legal information or any change in the circumstances that might affect what kind of services we're providing to that person seeking help. And like before, and as I said before, at the in-person, we'll only be providing legal information and limited brief services like filling out forms. Some people may need assistance completing documents, such as a housing conditions complaint or an answer in non-payment rent case or other kind of relatively simple pleadings, which we may be able to help with. Other people may need help reading a document or looking through a document, such as a notice or a lease, which is one of the advantages of being in person. It can make it easier to engage with the paperwork and the facts that might be impacting the kind of information we could provide. And at the end of the meeting, there'll be a form to fill out and give to the person seeking assistance with a summary of what was talked about, and which is similar to the follow-up email and Litify. And with that, I'm going to hand back to Kate to talk about legal information versus legal advice, which I know is not always an intuitive distinction.
Yes, legal information versus legal advice can definitely be a very confusing distinction, even for those of us who have been doing it for a while. It can still be a little bit difficult. So let's get into what those look like. So legal information is like very top level. You're really not getting into the weeds too much. You want to explain the law, the court's rules, procedures. You might want to talk about how does one affect service? How do you file? Like, where is the clerk's office? What can I request at an initial hearing? Burdens of proof, things like that. You can explain what to expect in court, like how the process usually goes. Is the clerk going to call my name? How do I call in? Things like that. You can explain court forms and documents. You can go through the pros and cons of options available, and you can explain potential outcomes. And a lot of this will hinge on the language that we use, and we'll talk later about what language helps make it information instead of advice. Advice, on the other hand, is applying the law to the facts of the caller's specific case, suggesting likely outcomes or even likelihood in general. So things like foreseeable outcomes and being like, oh, it's likely that the judge will grant this, right? That's more legal advice instead of just information. Offering an opinion on the caller's options, that is definitely in the legal advice column. So saying, if I were you, I would, definitely going to be a no-go. And we'll talk about some other ways to go about answering those types of questions. And here we are. So you do not need to say this out loud. You don't need to put it in the chat, but think about your answers to these questions as we go through this practice. So after going through your initial conversation with a caller who has an initial hearing in an eviction case coming up, and don't worry, we're not talking about substantive law yet. This is literally just what's advice, what's information. So the caller asks, can I choose a jury or bench trial? Which one should I choose? Think in your head for a minute, how might you respond to this? What language might you be using to make sure that we're using information instead of advice? All right, now let's go to the next slide. All right. All right, so now we've got some options. So your two options here that I'll give you, now you've thought about it, is A, unfortunately, I can't tell you which to choose. I can talk you through the potential outcomes for each of these, or based on your situation, I would choose a bench trial because you want to be done quickly. Give everyone a second or two to think about it. All right, let's show the answer. So you're gonna go with A. As you can see here, we're reiterating that we can't tell the caller which one to choose because that would be advice and just not what we're allowed to do. But you can talk them through potential outcomes for each. So you can still talk to them about the pros and cons and consequences that they might want to think about when making that decision. Here's another one. So you tell the caller you can't tell them, just what we said in the last slide, and then you talk them through the outcomes for each option of a jury versus a bench trial. Your caller then says, okay, I think the bench trial is best for me. Do I have to file anything? What would you file? All right, so let's go to our options. So two options again. You should file an answer. An answer presents your possible defenses and allows you to explain to the judge why you don't think you should be evicted. Or tenants can always file an answer, which presents possible defenses and allows a tenant to explain to the judge why they don't think they should be evicted. Take a couple seconds here. All right, let's show the answer, Paul. It's going to be B. I know when we talk to people, it is a lot easier to say you and say should and things like that. We're not saying you can never say you. We're definitely not saying that, but taking it into more of a third person response does make it more legal information than advice. So tenants can always do this, right? The caller knows they are a tenant. They know that that's going to apply to them. Or you can say you as a tenant, and tenants can, right? If you really want to get the you in there and make it a bit more personal, you can do that. But we want to make sure that we're keeping it broad and we're keeping it at that upper level. All right, I think we have one more here. Yep. So you explain the answer to the caller and they say, can I get a copy of an answer? I don't have email and technology is really difficult for me. We'll go to the next slide for our options because this one may not be as intuitive. All right, so we've got, yes, we have in-person services available at the courthouse that can help you with the answer and alert the LTRC supervisor. Or yes, you can find hard copies of answers at the clerk's office located in Court Building B. Give everyone a couple seconds, and there we are. It's actually both. So this one is why it's like, this isn't necessarily about info or advice. So like I mentioned earlier, when we have in person, we're able to do what you might call brief services. We're still not giving advice, but we are able to help people literally fill out the court forms. So we can sit there with them, have the court form printed. We can type their names into it. Like if they have trouble with handwriting, we can use the computers and help them literally fill it out. But they can also just go in person to the clerk's office and do it themselves. It's really an assessment of how much you think the caller needs more help and could benefit from in person, or how much they can go ahead and do it on their own. And then just to go over some common terms that we use that you might see in the supervisor's notes, or that you might hear when you're talking to a caller and you're not really sure what they mean. So DCHA or North Capital, common abbreviations for the DC Housing Authority. Section 8 is a catch-all term that's used to describe a wide number of housing subsidies. So if someone says Section 8, definitely get more information from them. Section 8 alone is not going to be enough to tell us which subsidy they have. If someone says they have a voucher, it is almost definitely the Housing Choice Voucher Program's portable voucher, which can be used anywhere in the US. Section 8, by the way, can describe the voucher and this project face down here, which is why I say we need a little bit more information if they just say Section 8. Project-based or site-based, if someone says those two, that's a federal subsidy and it stays with the unit. And then ERAP is DC's Emergency Rental Assistance Program. And we'll be talking a little bit more about ERAP and some of these things in the substantive training that's just going to follow. And some common abbreviations that we as supervisors use just to make our notes go a little bit faster and get all these callers out that we can. HCC stands for Housing Conditions Calendar. It's the section of Superior Court that handles affirmative tenant cases. LT, always going to be landlord tenant. DOB was formerly DCRA. It's the DC Department of Buildings that does the inspections in apartments. TRO is a temporary restraining order. A PO is a protective order. And the one that you will probably see us use all the time is abbreviating LL for landlord. A lot easier. You all are free to use it too, and we'll know what you're talking about. All right, so I think we'll open it up for any questions about this portion of the training before we move on to the substantive. And we may not have any.
I have a question, Kate.
Oh, is that Martin?
Yes.
Great, I can hear you. There you go.
As part of the training, I noticed that there was a option for shadowing somebody. How does that work?
So typically that'll be set up, Paul, with the firm itself. We've had firms before pair up someone who, like a veteran, someone who's volunteered in LTRC many times. And so they'll hop on like a three-way call when they call the caller. In person, obviously, you can literally be there and shadow us and watch what we're doing. But while we're remote, it's typically joining a three-way call, seeing how the conversation goes, sometimes getting on a Teams call and doing some screen sharing to see the Litify platform that we use. We largely leave it up to the volunteering firms to do the shadowing within, but I think we can work amongst, like, if you're coming in on a day where another firm is also volunteering, we can probably help cross-coordinate with that.
Thanks.
Okay, so I think we'll move on then to the next part of the training. You all just bear with us for a moment as we switch slides. I'm going to pause the recording. And again, you see here, you have our information to ask us questions afterwards, and we will. And thank you for that question earlier, but we'll be not only showing the training, but also the PowerPoints with everybody. Right, welcome back, everybody, to the next part of training. And here, as you can see, we're we're moving from talking about the procedures for the Landlord Tenant Resource Center to an introduction to landlord and tenant practice. And so I'm again going to hand things off to Kate to get us started.
Alrighty, so just to go over our sections and goals for today's training, we would love for all of you to come away with certain understandings. So the basic concepts and authorities that apply to evictions in the district, where people looking for legal information from LTRC may have to appear in DC Superior Court, because it could be landlord tenant branch, it could be a completely different branch. The parties' options in eviction cases, their options after a judgment is entered, and then finally, how to interview and provide legal information in a client-centered way. Alrighty, so just to get started, a tenant in DC can only be evicted through court process. There is no such thing as a self-help eviction in DC. That is extremely illegal. You can only evict a tenant through the court process. A tenancy in DC can be created through a written lease, an oral agreement, an implied contract. You don't have to have a written lease. You can be a tenant just because you and your landlord come up with an oral agreement. I'm going to pay you $500 a month to live here. And it also doesn't have to be for money all the time. You could say, I'm going to do this service to live here. I'm going to mow your lawn and take out your laundry, whatever it is to live here. But there's some type of exchange and agreement to live in the apartment. And a tenant, subtenant, or any other person entitled to occupy the home can sue their landlord for injunctive relief and damages if the landlord performs a self-help eviction, changes the locks, removes the property, or cuts off utilities, really any way that prevents the tenant from accessing their home. And there are specific reasons for which a tenant can be evicted in DC. The biggest thing that we see is tenants worried about my lease is expiring, does that mean I'm going to be evicted? That is not a legal cause for eviction in DC. Expiration of the lease is not a reason. So the landlord does have to give the tenant an appropriate notice. And there are a bunch of different notices depending on the reason for eviction. Your supervisor will definitely let you know which notice and how much time it needs to be. The notice has certain requirements for its content and also how it's served on the tenant. And the landlord has to submit the notice along with several other documents when they are filing an eviction complaint. These are the various authorities in DC for evictions. So the one that we look at most frequently, I would say, is the code, section 42-3505. We're in that one all the time. That has notice requirements. It has the reasons for eviction. It really spells out the process. But the Code of Municipal Regulations is also very crucial. We'll use this one a lot, especially when it comes to housing conditions. Both the housing code and property maintenance code are in the entire DCMR. And then we also do look at federal law. So both 42 USCA section 794 and 24 CFR section 8. So we got a lot going on, but we'll take all of those in turn and we'll explain them all as we go through this. So the District of Columbia Court of Appeals also has some rules that apply here. Obviously, the rules of civil procedure. There are also rules for landlord tenant branch specifically. A lot of landlord tenant branch incorporates rules of civil procedure. If you're ever not sure, you can check them with your supervisor, but the court also actually has a pretty great search function for the rules. If you were ever interested, you can go and take a look at those. They're open to the public for anyone to look at. There are also general order and judges supplements, as well as administrative orders. And those can both come in handy, particularly in housing conditions cases, but especially if you're looking for things like e-filing and how to do e-filing, what the court's operations are, logistical aspects. And I'll hand it over to Paul.
Thank you, Kate. So now we're going to talk a little bit more about DC Superior Court and looking at the different parts of DC Superior Court. So, and here we can see, here's a little graphic that shows the courts for tenant and landlord disputes in DC Superior Court. We have the Civil Division of DC Superior Court, and all of these other branches are parts of the Civil Division. And so landlords and tenants may bring legal disputes to several different branches and calendars, the Civil Division of DC Superior Court. And so landlord tenant branch, as we'll talk about more, is where eviction disputes happen. Civil actions branch is where a wide variety of disputes might be heard. And also where the housing issues calendar is located. Small claims and conciliation branch is for small claims, civil disputes that are only seeking limited money damages, which we'll talk about a little bit more later. And as we can see down here, there's on the civil actions branch, the associate judge calendars, which, as we'll talk about a little bit more, is where some landlord tenant cases might end up. And as I said, and the housing conditions calendar. And the Court of Appeals, the District of Columbia, takes appeals from all these courts. So these are all DC Superior Court, like parts of that, and the Court of Appeal for all of them is DC Court of Appeals. Focusing on landlord tenant branch, which again is what this presentation is primarily about. There's other disputes that landlords and tenants may have, which wouldn't be landlord tenant branch, but landlord tenant branch is where plaintiffs may seek possession of real property from tenants, foreclosed homeowners, and other persons alleged to not have a right to possession. And so while it's called landlord tenant branch, it isn't actually about any dispute between landlord and tenant. It's about one person removing someone else from a property or kicking someone else out of a property, whether that person is allegedly a tenant or not. The court enters a judgment for possession that allows the eviction to proceed if a plaintiff prevails, and that's how evictions happen. They need to get the plaintiff needs to get a judgment first, and then only then can they lawfully change the locks on someone and remove their belongings. A tenant who's been sued for non-payment of rent may counterclaim against their landlord for money judgment and injunctive relief, and some of the tenants that you speak to may have chosen to do that, or maybe considering that as an option, as a way to try to get some relief in the landlord tenant branch. In that case. And at the end, the court may enter money judgment in a non-payment of rent case if the tenant was personally served or filed a counterclaim for a money judgment. So here we can see the two different kinds of forms of relief available to plaintiffs in the landlord tenant branch, which again is really less the landlord tenant court and more the eviction court in terms of getting a judgment for possession that allows the plaintiff to kick someone out of the home or or whatever space they're occupying, or a money judgment, which allows the plaintiff to collect in the sense that they can garnish wages or get a lien on the property or do something else to collect the amount of rent owed in a way other than kicking them out. And as we'll talk about in a little bit, there is a way that either a judgment for possession gives leverage to a plaintiff, to especially a landlord in non-payment rent case, to get money. But for now, I think we're just focusing on these are the two different kinds of remedies available to plaintiffs in this branch. Other common forms for tenants in DC Superior Court, which we're not going to focus on in this presentation, but as you all may have seen, we're planning to provide other presentations, and one of them is about other rights that tenants have in the District of Columbia and how to assist with that. And so we'll talk more about these forms and options there in that training that's coming up. But there's the housing issues calendar, the civil actions branch, and the small claims and conciliation branch. And oftentimes, if a voluntary attorney is encountering these branches, this will be the context of a tenant who is complaining about having housing code violations in their home, and the landlord has failed to correct those housing code violations or failed to address problems in their home. And so the housing conditions calendar, the civil actions branch, is an option for a tenant to file a complaint seeking to have the landlord address these housing code violations, but that court may only award injunctive relief and sanctions, but not monetary damages. So a tenant can go there and potentially will get assistance, and that might potentially influence the landlord so that they make repairs, and the court might intervene so as to try to force the landlord to make repairs. But the court won't award damages, say, for the rent that they were paying when they had those problems, or let alone other issues like damaged furniture or something following from a failure to repair a leak or something like that. While small claims and conciliation branch is where a tenant or landlord may seek monetary damages equal to or less than $10,000, but does not award injunctive relief. So in a situation where a tenant is potentially seeking some kind of relief for housing code violations, they have these different forums. But as you can see, they would, if they want to get money and they want to get stuff fixed, they would have to go, if they have problems fixed, they'd have to go to more than one. They can't go to just one of these forums. And with that, I'll hand it back to Kate to talk a little bit more about
Alrighty.
tenant branch.
Yeah, so next up, we're going to talk about practice and procedure in the landlord tenant branch. So how eviction cases are handled and the chronology of an eviction case. If you volunteered with us before, you probably know that we spend a lot of time talking about this with our callers. So practice in LT branch, courtrooms are handling everything hybrid right now, and we expect that that'll probably still be the procedure for the foreseeable future. For the most part, initial hearings are all remote. Mediations are actually largely remote. A few exceptions being trials, occasionally motions hearings, but it really does depend on the judge and how they're feeling. For the most part, it's all hybrid with a lot of remote options. And there is public access for all of the remote courtrooms. If you even just wanted to go in and observe, you can follow that link and observe any day, anytime. The court will let you in and you can just take a look at what's going on. There are a number of forms and pro se pleadings available at the court's website. We use a couple of those when we talk to our callers. And then there's also the portal to search for cases. That is now Odyssey. So the court did a change last year. So we're now using Odyssey. And then we also finally have Law Help and probono.net. We manage both of those websites. We put up a lot of pro se materials and also practice materials for our volunteers who take on full representation cases at probono.net.
Thank you, Kate. So now we're going to begin getting into more of the substance of eviction cases heard in the landlord tenant branch. And Kate and I are going to, I know you might already feel like we've been throwing a lot of information at you, but we'll be throwing even more information at you now. But I think something really important to remember is what we said earlier, that anytime that you're actually volunteering with Landlord Tenant Resource Center, you're going to have a supervising attorney who, like an LTRC supervisor, that's going to give you a lot of guidance about what information to provide to the landlord or tenant in a given situation to help them. And so this is really designed to help give you sort of a framework to hope, to begin better understanding the legal issues involved in an eviction case, but we're not in any way, you don't need to have this all memorized before your first day that you're volunteering with the resource center. And again, please, if you have questions, please put them in the chat, and we'll try to certainly address at least some of them, while at the same time try to just cover everything that we're covering. So the eviction case, or how landlords bring and tenants defend eviction cases. So beginning with how to start an eviction case, the landlord must have a current license for rental housing and a valid registration or claim of exemption filed with the Rental Accommodations Division of the Department of Housing and Community Development. This is part of the numerous additional requirements that the law has placed on landlord for bringing eviction cases against tenants. So those need to be, that's something that the landlord really does have to have in almost all instances before filing a case, those documents. A landlord must serve the required notice on the tenant in the required manner, and this is something that Kate described earlier. For any eviction case brought against a tenant, there does need to be a notice given to the tenant. And a person that a plaintiff alleges is not a tenant may not be entitled to a notice. So if someone says that, if someone who owns a property claims that the person who's living there isn't a tenant for whatever reason, then that is an exception from all this. But again, if a landlord is seeking to evict someone that is a tenant, then they'll need to go through all this process, which includes a notice delivered the proper way. Here we can see a comparison of the very similar but not exactly identical requirements for service of the notice and the complaint. There's slightly different requirements under the law for a landlord serving a notice to the tenant versus serving the summons and complaint onto a tenant after they file the lawsuit. So regarding the notice to the tenant, a landlord may serve the notice on the tenant in person. A landlord may serve the notice on another person of proper age upon the premises. And that roughly means 16, but maybe not, but it isn't as exactly defined as for summons and complaint. A landlord may serve the notice by promptly posting the notice on the door and mailing the notice by first-class mail within 3 days of posting. And if the landlord served the notice by posting and mailing, then the landlord must file a timestamp photo of the posted notice with the complaint when they file the complaint. And so they also need to take a photo of having that notice on the door when that happens. And an important point here, and this is a difference between serving a notice versus serving the notice and complaint, a landlord or landlord's agent may serve the notice. So if you have a small landlord, which is the kind of landlord that you may be talking with, who doesn't have a management company, they can give the notice themselves. They can walk up and hand it to the tenant. They can mail that notice to the tenant themselves, which is different than with the complaint and summons, which that small landlord would need to get someone else, a process server, or someone else who's not the landlord, to give that summons and complaint. And moving over, and again, this looks very similar, but not entirely the same. If for the summons and complaint, which again is what the landlord has after they file, they're going to fill out a complaint and file it with the court, and then they'll also get the summons, and they need to serve that on the tenant prior to the initial hearing, which we're going to talk about a little bit more when we have a broad view of the procedure. A landlord may serve the complaint and summons on the tenant in person. A landlord may serve the complaint and summons on a person above the age of 16 years on the premises. A landlord may serve the complaint and summons by promptly posting them on the door and mailing them by first-class mail within 3 days of posting. Similarly, with the notice, a landlord must file a timestamp photo of the posted complaint and summons with the court. And this is included usually with the proof of service of the complaint and summons. And that needs to be filed 21 days before the initial hearing. If the landlord doesn't do that, then there's a risk that their case is going to get dismissed. And as you can imagine, for the larger landlords, like property management companies or landlords that are in the business of this is, well, I'm not going to say they don't make mistakes for a variety of reasons, but for smaller landlords, they can sometimes struggle with all these different processes. And so here you can see this is a sort of overview of landlord tenant branch proceeding up to the initial hearing. There's and so we just described the eviction notice being served. You can see that's sort of the first step in this process. The landlord serves the eviction notice on the tenant. Then after the time has passed, and depending on what's the basis for the eviction, there can be different time periods. It might be 30 days, it might be 60 days, it might be 90 days. There's a variety of different time periods for that notice, depending on what's the basis of the eviction. But after that time passes, then the landlord can file an eviction complaint and serve the complaint and summons on the tenant. Then they file the declaration of service of a complaint and summons with the court, and they should do it at least 21 days before the initial hearing. And then we have the initial hearing. And then looking to the initial hearing, like what is the initial hearing, which I think is a question that certainly as a volunteer, you'll hear a lot from landlords and tenants. I often think of it as it's the option for the tenant to respond to the landlord's complaint. And they have a variety of different ways that they could potentially respond, especially if they have one or more defenses to the complaint. If they have no defenses to the complaint, they're in a harder situation. But the options then at the initial hearing, which as Kate was describing, these are hybrid. So a tenant or a landlord can attend these in person or remotely. If they're going in person, they're being held in Courthouse B of which is the courthouse that houses the landlord tenant branch and various hearings there. There's also a link that can be attended. But at the initial hearing, these are the options that we're going to go through that the tenant has for how they want to respond. And you'll see here, there's also something called the further initial hearing. And a further initial hearing is basically an initial hearing that's been continued to give the tenant more time to figure out what they want to do. At least that's how I would characterize it. And really, further initial hearings are very similar to initial hearings, with the difference that it's less likely that after the tenant gets one continuance that they're going to get another. But otherwise, the options are generally the same at an initial hearing to a further initial hearing. So, as you can see, one option is for a tenant is to request a continuance to a further initial hearing. And one of the most common reasons that a tenant can give that is likely to get their request granted, especially at an initial hearing, is that they need more time to find an attorney. The court will almost always give a tenant a continuance to find an attorney from the first time they're in court. Afterwards, it's far less likely, but again, depending on the circumstances of the case, they may be able to convince the judge to give them more time. A tenant can also make an oral motion to dismiss, or if there is something on the record that is a basis for dismissing the case, like a defect on the notice or some other problem like that. A tenant may also have a trial set before a judge. So if the court determines that there appears to be some kind of defense or some dispute about the facts that is appropriate for trial, then the court might set a trial before a judge in the landlord tenant branch to determine those facts and to make a decision about the case. A tenant can also file a written answer setting a trial before a judge or certifying the case for a trial before a jury. And as you're going to see, there's actually, broadly speaking, two fairly different procedures that tenants and landlords may go through in the landlord tenant branch, depending on whether the tenant keeps the case in the landlord tenant branch and doesn't ask for a trial before a jury, or which is a shorter process, or if they file an answer with a jury demand, then the case gets sent to an associate judge in the civil actions branch, and there's like a longer process that is not this identical, but similar to the kind of process for any other civil actions branch case. And we'll talk a little bit more about the differences in those processes later, but that is one of the options that tenant has, to file an answer, get one of those either, and get to trial one of those two ways. The court may also enter a confessed judgment against a tenant. And so earlier I was saying that a tenant has several options, especially if they have defenses to the case. So the court determines that they don't have any defenses. So for example, if a tenant is at a non-payment or is sued for non-payment of rent, and they're at the initial hearing, and the court asks why they didn't pay the rent, and they answer because they lost their job. And I think the judges generally try to ask more questions to see if there might be some other defenses there, even if they're not clear to the tenant that they're a defense, like that the landlord failed to repair housing code violations, address housing code violations. But still, ultimately, if the court determines there isn't any dispute about the facts in the case, then they may enter confessed judgment. And from there, the landlord can proceed with the eviction process. The tenant may also lose their right to a trial before a jury. So if a tenant seeks a continuance or sets a trial before a judge, then under the rules of landlord tenant branch, if the right to a jury is not reserved or used, then it's lost. So that's another possibility of what might happen at an initial or further initial hearing. And the court may discuss the agreement with parties before entering it. So if the parties have entered a settlement agreement, that's a big if here, then that also might be something that's discussed at an initial hearing or over a further initial hearing. And we're also going to talk about, this isn't an option here in part because it's not something that really, generally a tenant would not choose this, because they generally would not further their goals. And we're going to talk about this in more detail later in the presentation, but it's also possible a default might be entered against a tenant. If they don't show up at the hearing and they don't take some action to get that hearing continued, then a default can be entered against the tenant, which means that they don't necessarily a judgment won't immediately be entered necessarily, but they lose the ability to assert defenses in their case. And there are options, if that happens to a tenant, for them to vacate that default and get their case back on track to being able to contest the claims that the landlord brought. But as you can imagine, something has to be done by the tenant to make that happen. And so here we can see this graphic is trying to help show what happens after the initial hearing. And as you can see, there's a bifurcation depending on, well, actually on two things. One, whether or not something happened at the initial hearing or a further initial hearing. And as you can see, it's actually the same, except probably after a further initial hearing, you could keep on, like, theoretically, there's a good reason there could be continuances for a long time in a case. But basically the options from an initial hearing or a further initial hearing are the same. And then the difference is whether a trial was set with a jury demand or a trial was set or without a jury demand. And so here, as you can see on top, and then in also the third row, if there isn't a jury demand, the next course setting will generally be a mediation, which is an opportunity for the parties to try to enter into a settlement agreement with the assistance of a neutral third party. And then there'll be a trial before a judge. And that'll generally be in the landlord tenant branch, as I said earlier, unless the tenant didn't consent to a magistrate, and then it might be before an associate judge. And if an answer with a jury demand was filed, then there's discovery. The parties are entitled to discovery if a jury demand is filed, and there will be a close of discovery set, which is sort of the deadline to complete discovery. And if the parties can't complete discovery before then they might want to continue or extend that deadline, so they can do so. And followed by mediation, followed by a pretrial conference, which is the opportunity to basically address issues related to trial before the trial. So things like jury instructions, verdict forms, motions in limine might be decided, other matters related to the conduct of the trial, and then the jury trial at the end of the process. And discovery is potentially available either way. But if a case is not certified, is not sent for a jury trial, not certified the civil actions branch for a jury trial, then discovery is generally only available by leave of the court. So by written motion or by an oral motion, or it takes kind of process to get leave to do discovery. And here we can see a little bit of what I already shared in terms of kind of contrasting the two different kinds of options in terms of how the process differs whether the merits are decided at a trial before a jury or a trial before a judge without a jury. With the trial set with the jury demand, the court may set a mediation followed by a trial. Without a jury demand, the court may set a mediation followed by a trial date. Witness and documents may be subpoenaed for trial, and the parties may file a motion for leave to conduct discovery. If the answer jury demand was filed, the court may set a closed discovery followed by mediation. For a while, they also set pretrial conferences at the same time when an answer and jury demand was filed, but the courts stopped doing that. It doesn't mean they won't start again. Now, a pretrial conference will be set after mediation fails, basically. And if a case is certified the civil actions branch for a jury trial, that associate judge in the civil actions branch the case is certified to will handle most matters in the case, but not all. And the trial will take place after a pretrial conference. And now here, we're going to talk, this is a little bit more discussion of like non-payment rent cases and sort of just the basic prima facie case that a landlord needs to prevail on to prevail in a non-payment rent case. So they must show, so in non-payment rent cases, a landlord must show that a landlord-tenant relationship exists between the plaintiff and the defendants, the defendants fail to pay $600 or more in rent to the plaintiff, and that $600 is a relatively recent change to the law, setting a minimum that needs to be alleged not have been paid by the tenant. And the plaintiff gave the required notice of past due rent to the defendants at least 30 days before the complaint was filed in the required way. And here I want to highlight a really important point, and we're going to touch on this in different ways as we throughout the rest of the presentation, but a tenant may halt an eviction before a case is resolved by paying the rent the landlord alleges is owed. And a tenant, and as we'll see later on, a tenant can also halt a non-payment or rent case basically at any point before the locks are changed under a judgment for possession by paying the landlord either what they allege is owed, or if there's been a decision on the merits about how much is owed, say in a trial, then by paying whatever the court says that they owe. And that segues to emergency rental assistance, which, as Kate mentioned earlier, is a way that tenants can get emergency rental assistance in the District of Columbia. Emergency Rental Assistance Program, or ERAP, provides overdue rent to district tenants earning less than 40% of the area median income. Tenants may apply for ERAP at this link. Right now, tenants cannot apply for ERAP. It's closed, should close in the spring, but our understanding is that in the fall, there'll be more money and tenants will be able to apply for ERAP again, perhaps in October. And so certainly that'll be very important for tenants around that time who are seeking ERAP as part of the solution to avoiding eviction in their cases by helping pay off what they owe. Tenants may also call 202-507-6666 or email erap@housing-etc.org to learn more about ERAP and to inquire about their application. And this is another important point. The court must stay non-payment of rent proceedings while tenant's application is pending. And so this is a relatively new law as well. So to some degree, it's being disputed exactly how this applies. But I think certainly from a tenant's perspective, at any point in the case, if they have a pending ERAP application, the case should stop. So if they have an initial hearing and they have a pending ERAP application, it should be continued. If they have a trial and they have a pending ERAP application, it should be continued. And also, as you can see here, a landlord must reschedule an eviction date when the tenant informs them of a pending ERAP application. So we'll talk later about how to prevent evictions, like prevent the actual changing of the locks once the judgment's been entered. But this is one of the bases to stop an eviction once the judgment's been entered, if there's a pending ERAP application. And so moving on to touch briefly on other non-payment rent defenses and counterclaims. We've been referencing already one of the major affirmative defenses, and we call it an affirmative defense because this isn't part of the landlord's prima facie claim, but it's a defense that a tenant can bring, and then they have to, they have the burden of proving. But that's a breach of the implied warranty of habitability, that the landlord failed to correct housing code violations, and for many tenants in the District of Columbia have that as a defense in their non-payment rent cases, because the landlord has at some point failed to correct a housing code violation or is continuing to blatantly not correct housing code violations. Similarly, void lease is a very similar, but not exactly the same affirmative defense that the landlord failed to correct unsafe or unsanitary conditions. And another common affirmative defense is a landlord suit or retaliation for the tenant asserting their rights in some way. Substantive defenses is a way of describing defenses where the tenant can disprove part of the plaintiff's, the landlord's prima facie claim. So tenant's not if the plaintiff is not the tenant's landlord, that's a defense to non-payment rent. If the tenant does not owe the rent, if they paid some of it, or all of it, that's a defense to non-payment rent. If the landlord served an inadequate notice, that's also a defense to non-payment rent. Another kind of defense tenants may have are procedural defenses. We talked already about there being quite a few procedural requirements for landlords. So if the notice of past due rent was improperly served, if the required documents are not filed with the complaint, if the complaint was improperly served, these are all potential arguments as well that a tenant could have. And then moving on to equitable defenses and counterclaims. Equitable defenses are basically ways for the tenant to go beyond the scope of the plaintiff's complaint in terms of reducing how much they owe. And so recoupment is an argument that rent payments the tenant made before the landlord alleged failure to pay rent should reduce how much they owe. So let's say the landlord sued for a year of rent, but the tenant says they've had problems in their home for 3 years. Then a tenant could potentially use those 3 years of problems to reduce how much they owe rather than that 1 year of problems. And set off is an argument the tenant can make to say that they spent money to correct housing code violations. The money they spent to correct housing code violations can reduce what they owe. And a big difference between these equitable defenses and counterclaims is the equitable defenses are just additional ways to basically reduce how much the tenant owes in some way in an non-payment rent case. While counterclaims are actually, as counterclaims are claims that the tenant is bringing against the landlord, and could potentially entitle the tenant, if they prevail, to a remedy. So if a tenant may counterclaim for a money judgment for breach of the implied warranty habitability, apologies, and void lease for up to 3 years back. And if they prevail on that, they might not only reduce how much they owe, but they might actually get a judgment against the landlord, which happens certainly. The landlord might end up owing them money. Or the tenants may counterclaim for injunctive relief, which would allow them to get a permanent injunction requiring repairs, say, to the home, and could also be a vehicle for the tenant to file a motion for a temporary restraining order or for a preliminary injunction entitling them to a TRO or preliminary injunction relief related to repairs as well. And so another issue that comes up in non-payment rent cases that you may encounter as a volunteer, or you're likely to encounter as a volunteer, are protective orders. In non-payment rent cases, the landlord is entitled to ask the court for protective order. And here, protective order means something very different than in many other contexts. Many of you may have heard of protective orders in the context of discovery disputes or in the context of seeking relief from someone who is a violent danger to someone else. But here, a protective order is an order requiring the tenant pay their rent into the court registry while the case proceeds, or an amount of money that's based on their rent while the case proceeds. If the tenant fails to pay, the landlord can file a motion asking for sanctions, which can lead to problems like the tenant losing their right to a jury trial or losing the ability to assert their defenses in their case. So it could be a pretty bad result. And this amount, if there's housing code violations or other disputes about the rent level, the tenant can ask for a bail hearing. And this is something that usually happens at an initial hearing or further initial hearing, where the tenant, if the landlord asks for a protective order and they're asking for whatever the rent is amount that they allege to be the protective order, then the tenant can ask for a bail hearing and that could be a way to reduce the amount they're paying into the court registry over the course of the case. An important point here is that while the protective order is based on the rent, it's not an actual adjudication on the merits of what the rent should be or not. So the money goes into the court registry, but depending on how the case is resolved, whether through trial on the merits or settlement or some other way, that money gets distributed depending on that. So the money could go back to the tenant, it could go to the landlord, it could be split between them, depending on how the case is resolved. Other eviction claims, and again, we don't have time to go into detail on all the different kinds of eviction claims. We focused on payment of rent because that's the most common kind of eviction claim that you'll be encountering from tenants. But other eviction claims include tenant failed to correct a violation of an obligation of their tenancy, which often means a violation of their lease. And another is that federally subsidized tenants violate an obligation of their tenancy, requiring them to avoid criminal activity. And as you'll see, if you're speaking with someone that has one of these problems, there's more stringent prohibitions on tenants in federally subsidized housing regarding criminal activity than otherwise. Another court found that tenant performed an illegal act. That's another basis for eviction. Landlord or the purchaser of the home wants to move in. That's another basis for the eviction if they want to move in for personal use of the property. or tenant must move out temporarily to renovate the home. And these aren't all the other reasons under the code that are allowed for evictions, but these are many of the other kind of claims that a landlord could bring against a tenant to evict them from the property. And again, just to briefly go over some of the defenses to other eviction claims, affirmative defenses include the basis of the landlord's claim is an interfamily offense against a tenant or their child. So if a landlord is seeking to evict someone because they allegedly violated the lease, but the tenant but the tenant can assert that the alleged violation of the lease was them being the victim of domestic violence, for instance, then that would be a defense to that case. Landlord's claim violates district or federal anti-discrimination laws. So, for example, if a landlord is seeking to evict a family because they have a child who's not listed on the lease, which does happen, unfortunately, that would be probably a violation of district and federal anti-discrimination laws. A tenant is entitled to reasonable accommodation for their disability. It's another affirmative defense that could be available to tenants with disabilities. And that is a fairly common argument in many cases where there is a alleged lease violation by the landlord. Violation of lease obligation is not a material breach. So there was a violation of the lease, but it wasn't so serious as to lead to someone being evicted. Or landlord suit in retaliation for the tenant asserting their rights, which is similar to the defense we described earlier for non-payment rent cases. Substantive defenses, and again, these are defenses where the tenant doesn't have the burden, but said the tenant can show that the plaintiff can't meet their burden to prove their prima facie case. Examples would be plaintiff is not the tenant's landlord, tenant did not violate an obligation of tenancy and or corrected the violation if they have the right to do so. The court did not find that the tenant or household member committed an unlawful act at the home. The landlord or the purchaser is not intending to move into the home, or landlord served an adequate notice. Again, take one of the elements of the plaintiff's complaint and knock it down, and that would be an argument for why the tenant should prevail. And procedural defenses, similarly, notice of past due rent was improperly served, or the notice was properly served, apologies. Whatever notice that needs to be done, required documents not filed with a complaint, or a complaint was improperly served. And with that, finally, I can hand back over to Kate to talk a little bit more about resolution of the case.
Yes. All right, so we're going to go through the two main options that we see for resolutions and the two main ones that we talk about with callers. So up first, we've got, Paul, if you wouldn't mind the slide, thank you so much. First, we've got settlement agreements. We see these very, very commonly, especially in non-payment of rent cases, but you also see them commonly in lease violation cases. So settlement agreements and non-payment of rent cases, obligations can include things like a payment plan, a lump sum payment, repairs that the landlord has to make, a neutral reference for the tenant once they move out. The landlord can enforce the tenant's obligations through a motion for judgment, or they can apply to terminate a stay on a consent judgment. If the judgment is redeemable, the tenant can still redeem. They can still get their apartment back by paying off that amount. In other cases, obligations can look like the tenant avoiding specific conduct, the landlord changing their conduct and policies, repairs, or again, a neutral reference. And the landlord may also, again, enforce the tenant's obligations through the motion for judgment or apt to terminate the stay on a consent judgment. And then our last resolution, judgments, unfortunately, judgments for the landlord. So if a landlord gets a redeemable judgment for possession, then they prevail on the merits in the non-payment of rent case. There will be an amount that the tenant has to pay to prevent the eviction. It will increase each month, and landlords can obtain a money judgment if they personally serve the tenant or if the tenant counterclaimed for money damages. In a non-redeemable judgment for possession, tenants can only prevent the eviction by setting aside the judgment, moving out before the eviction takes place, or some other agreement to prevent the action. So it's a little bit more difficult with non-redeemable judgments.
Thank you, Kate. And now I'm going to try to go through this quickly. Evictions after judgment or dismissal. So, so if we get to the after a judgment, there's a landlord has to get a writ of restitution to be able to complete an eviction, to lawfully evict the tenant from their home after the judgment for possession is entered. A landlord must deliver a notice to the tenant informing them of the eviction date no fewer than 21 days before the eviction. Landlord must provide notice by telephone, electronic communication, and first-class mail and posting at the home. So that's 3 ways: by telephone, or some of the by electronic communication or first-class mail and posting at the home 21 days before. And a tenant is entitled to quash the writ and stop the eviction if the landlord fails to comply with these notice requirements. And this is one of the great reasons, besides the fact that maybe the tenant's going to be able to pay the rent, or there's a default against what they can vacate, that they might be able to quash the writ. And for 7 days after the eviction, the landlord must give the tenant access to their former home to recover their personal property. And we talked a little bit about applications to stay or quash the writ. That's what a tenant may file to stay the writ of restitution, to stop a scheduled eviction. The form still says stay, but in function it's quashed, and stay means it's paused, but quash means it's squashed. They have to get a new writ after that to actually do the eviction. The writ will be quashed, stopping the scheduled eviction if they prevail on their application at the hearing. There'll be a hearing set after the tenant files an application to stay the writ of restitution. After the writ is quashed, the landlord will need to have the court issue a new writ. The court may quash for a variety of reasons, including that a default judgment should be vacated, but the tenant will soon redeem, and the court must quash the writ if the tenant has a pending emergency rental assistance payment. We talked a little about defaults before and default judgments. A default may be entered against a tenant if they fail to appear at a hearing or trial. A default judgment may be entered against a tenant when they have not made an appearance in the case after the landlord files a Service Member Civil Relief Act affidavit. The default judgment may be entered against a tenant if they fail to make an appearance after the initial hearing or after the landlord prevails at an ex parte proof hearing. And that's an ex parte proof hearing is basically a hearing where only the plaintiff can make arguments and provide and put on evidence. The defendant, if they attend, may only be able to object. And they're pretty limited what they can do. And the ex parte proof often will be set for a date after the default was entered, unless the default was entered at trial. And then usually they'll just proceed with the ex parte proof. And to vacate a default judgment, the tenant may move to vacate a default or default judgment entered against them by showing that they not willfully neglect to litigate the case, which basically means that they have some kind of reason, even if not a particularly great one, for missing the hearing. They may assert meritorious defenses demonstrated in a verified answer. So they have there's a reason to have a trial because there are defenses. They do not unduly delay in filing the motion. They bring the motion in good faith, which basically means that everything above is satisfied, and any prejudice to the landlord is outweighed by other factors. And vacating, dismissal, failure to prosecute. This is a situation that might happen if a landlord fails to show up for a hearing and their case is dismissed because they weren't prosecuting the case. The landlord may move to vacate or dismissal if their complaint was dismissed for failure to prosecute. They must file a motion to vacate the dismissal within 14 days of dismissal, and landlords must show good cause for the case not being dismissed. And then last, for sealing eviction records, in terms of the substantive part of the presentation, court should automatically seal resolved eviction proceedings 30 days after resolution if landlord does not secure a judgment for possession, or 3 years after resolution if a landlord secures a judgment for possession. Tenants may move to seal all records of an eviction proceeding if the tenant shows the landlord sues for less than $600 and they meet any of these criteria, or they meet these criteria. Tenant evicted from subsidized home, the eviction suit was brought in retaliation against tenant, landlord failed to timely correct housing code violations, protections related to domestic violence, dating violence, sexual assault, or stalking apply to the eviction, settlement agreement did not give landlord possession, or court finds other reason to seal. And so now, unfortunately, we have less time than we wanted, but I'm going to hand back to Kate to talk a little bit about clients and interviews, which is an important part of what we do as people assisting tenants and landlords.
Absolutely. So client-centered interviews and making sure that our practices are centered around the community and the customer community that we are serving is really important. It's how we make sure that our customers, callers, etc., feel heard and also feel like they are getting the help that they need. So to get started, we'll talk about what is client-centered lawyering generally. Client-centered lawyering is holistic. We take into account the client's unique goals and situation in life. We put aside our implicit biases, and we factor in our clients' lived experiences. And this type of lawyering applies even when you're only providing legal information. It's an approach and an outlook that can apply to your entire practice. In the context of interviewing community members in LTRC, this means listening to someone's goals and their situation, putting aside your biases, and being curious about their experiences in any other context they can provide. All right, so next up, we're going to talk a little bit about implicit bias. I'm going to start with what is implicit bias. Give everyone a second to think about what your definition of implicit bias is. And we have another training, by the way, client-centered lawyering later this year. We will get way more into all of these topics, but this is to give everyone a primer. All right, so we'll pull up the definition now. So implicit bias refers to the brain's automatic instant association of stereotypes or attitudes toward particular groups, often without conscious awareness. We all have implicit biases. All of us do. I do. Paul does. You all do too. That is okay. It's important to acknowledge and recognize our biases, though, so that we can prevent them from causing harm in our interviews and in providing information to our customers and client community. All right, so how do we remain client-centered when we're doing these really brief interviews and we're on phone calls with people? Some things that we want to avoid: assumptions overall, assumptions overall, but particularly about facts, values, and goals. Judging callers' actions, values, or goals, substituting your values for the person that you're talking to, or shutting down someone's narrative or expression of their goals and values. We really want to make sure that we're avoiding those. And instead, we can encourage our callers and our customer community to share with us their experiences, to talk to us about what's been going on. We want to make sure that we're expressing empathy when we're talking with our callers. We can question our own assumptions. So if we do have an assumption, it'll probably happen. Make sure that we're questioning it after. And then finally, we really want to make sure that we center providing legal information based on the client's values and goals. So last up, we have a little model interview here. I think Paul's going to come in and help me talk it through because I know this text is a little bit small. So let's say you are at the LTRC. You have your lovely customer, Paul. He comes in. So it's nice to meet you. My name is Kate. I'm a volunteer attorney with LTRC. I'll be talking to you about your legal issues and then going over legal information relevant to your issues.
Thank you so much. My landlord is trying to kick me out because I have a service dog. I can't believe it. I'm so upset. This isn't fair. I really don't want to move because of something that's not even my fault.
I hear you. Service dogs are really important, and it must be really frustrating to be going through what you're going through. Can you tell me a little bit more about your service dog?
Oh, he is so sweet, so well behaved. You would never even know I had him.
Have you ever talked to your landlord about him?
Yes, I actually went to my doctor and got them to write a note explaining why I needed him.
Great. So a tenant in your situation has arguments for why their landlord should lose. I'm going to go get a copy of our checkbox answer, and we can fill that out together to get you started in your case. And scene. There we go. So that's a little example of ways that we can try to interact with our clients, get a little bit more information. You want to have some introductions. You want to allow the client time to speak, to tell their side of the story. You want to allow them time to add some goals and stuff. To Paul, it's very clear that he loves this dog and that it's a well-behaved dog, and it's very important to him to have this dog. And if we didn't allow our callers, customers, clients time to talk to us about their goals and to see it from their perspective, we might not know what else they did. We might not learn that they did go to their doctor and that they actually have done a lot of the steps and that their landlord is in the wrong. So we get a lot more, not just in terms of how to help the customer, but also literally legal information and other ways that we can help them out from that aspect. And I think that's everything. I think we did it.
Yeah, thank you so much, Kate. And I think also just on this point, also, this is something else to talk about with the LTRC supervisor. If you're speaking with someone like many of the people that are calling us, they're not calling us in the best moment in their lives. So certainly if you're having challenges and trying to think about how to empathize or how to like engage meaning constructively with someone who maybe you're finding a hard time, you want to listen to their story, but you're also having a hard time asking the questions you want to ask or giving the information you're trying to give after guidance from a supervisor about that. That's something definitely to talk about with us as well. And we can try to help you not only with identifying the information to give the caller, but also to how to approach the caller in a way that centers them while at the same time helping you, actually provide the service that you're trying to provide. So yeah, thank you so much to everyone. I know that I'm sorry that we wanted to give a little more time for questions during the time we gave you, but we're happy to stay on to answer any questions you may have. Also, we have upcoming trainings as Kate mentioned coming up and throughout the coming months. So we encourage you all to also attend those trainings if you're interested, and have your colleagues attend those trainings. But please, if people have any questions now, please let us know, either in the chat or if you want to raise your hand or just call out the question. Great. Well, thank you again so much. Again, we'll stay on. If a question occurs to you in the next few minutes, we'll still be here, I think. But thank you all so much for coming to the training. Again, we'll be sharing the video recording and the PowerPoints with all the firms so that you'll be able to access them. And we'll also be putting at least some of that onto probono.net as well. And again, we really appreciate your time. We really appreciate you volunteering to help our callers and to help us provide legal assistance to people that otherwise wouldn't be getting any legal assistance at all. It's really important. Thank you.
Hi, Paul. Russell has a question, so he will stay online.
Yeah, that's great. Yeah, so thank you so much, Adej. Yeah, so Russell, what question?
Hey guys, thanks for the training. Very helpful. You know the thing I just can't, and I don't know why I'm thick about it, but I have trouble processing the intra-family defense. Can you just, I think I said it right. Can you maybe just restate it or say it again or explain it? I just want to make sure I'm following because for whatever reason it just doesn't click in my head.
Oh, of course, that's a great question. And there's lots of things. I think that we're going, as we said, we were going over things pretty quickly. So there's lots of stuff that probably you need to talk with an LTRC supervisor to get into more of an understanding about. But so that defense means, so for me, it's helpful to think, first of all, that there's certain kind of claims that might be related to tenant conduct that often violates at least or is allegedly criminal conduct. So the example I gave before is let's say that someone's being sued because they violated their lease because their lease says that they can't create loud noises or something like that. That's a common prohibition in a lease. And the landlord sues them alleging that they made a loud noise once and then they failed to correct that, so that there have been loud noises over a long period of time. If the tenant can then say, well, look, the reason why there's loud noises is because my partner is abusive and comes and starts fights with me. Then that would be a defense to that case. Or likewise, a different cause of action is that if a court, would be related to like, well, it's actually less likely. So let's just stick with this example, I think, that I already started with. So that would be an example of how the defense might apply in that situation. Or, if you can distinguish that the person who's being sued was a victim in some way of intrafamily offense or dating violence as defined under the statute.
That clarified it. So thank you. Yeah, got it.
Yeah, thank you.
Yeah, that makes sense.
Great.
Paul, we also see it pretty frequently. Just to add one more, Russell, like if someone's not on the lease and they say someone's living with you, that's not on the lease and that's in violation of your lease. and it's someone who is being abusive and is showing up to the apartment, and the tenant has tried time and time again to get the person to stay away from them, but they keep coming and coming and coming. I've seen that happen too. So just like another context in where that might pop up.
Yeah, so it's almost providing for like circumstances or recognized circumstances outside of the tenant's control. I mean, oversimplification maybe, but that's what it sounds like.
Yeah, I think that's yeah, I think that sounds right, especially like in the context of dating or domestic violence of some kind. But I think it's also, it's helpful to be thinking about like what are the ways, like what's, often like there's a good fact, like this seems like there's something outside the tenant's control, often then seeing where the law go to help then support a defense there as well.
Okay, good. Well, thanks for taking that question.
Of course. Thank you so much, Russell. Does anyone else have any questions? I'm actually going to stop the recording now, not because these questions will be great, but just